A bunch of you pinged me about KuttySarkArt here. Riot Games claimed my original artwork is their intellectual property. I'm just some girl from Ukraine and have no voice if such a big company as Riot Games claims that my work belongs to them, even if all facts prove them wrong. The only thing I can do is speak here. She says, yesterday I received an email from TeePublic informing them that a t-shirt design created by me as merchandise for my original comic, Arcane Flames, was taken down because Riot Games Incorporated have sent a DMCA takedown notice claiming that said design is their intellectual property. Here's the TeePublic message, purportedly. Dear KuttySark, we're sorry to inform you that an intellectual property claim has been filed by Riot Games Inc. against this design of yours on TeePublic. Arcane Flames, Elvis. How this works. Unfortunately, we have no say in which designs stay or go. According to our intellectual property policy and the law, we are required to remove designs when a rights holder sends us a valid takedown request. For more information, you can check out this article or read the DMCA in full here. I'll get to her notes in a moment. A note from us, we note that takedowns can be frustrating and at times feel vague, but I hope you can appreciate that we have to comply with the procedures required by the DMCA and similar laws. If you truly believe this was a mistake or want to file a counterclaim, please don't hesitate to reply to this email. And she writes, rights holder, valid takedown request, I have no words. And then this is the design in question. This art depicts Alvis, the main heroine of my comic Arcane Flames. Even the t-shirt has my logo of my comic on it. So of course, Riot Games should know that this is not something from, I guess, League of Legends or one of their other properties or something. I have a few issues with this. First of all, we must comply with the law. We have to comply with the procedures required by the DMCA and similar laws. The DMCA requires nothing. No, it's a misnomer. The DMCA is not actually required. The DMCA is a way that TeePublic or other content hosts can stay within the copyright immunity or the safe harbor provided against copyright claims. So TeePublic complies with the DMCA, then they can't be claimed as the copyright infringer. So to say that they have to comply with the law, well, no, they choose to comply with the law because they want to be in their safe harbor. Then they write, if you want to file a counterclaim. It's not a counterclaim, it's a counter notice. How this works is the DMCA allows TeePublic to stay in their safe harbor from being accused of copyright infringement successfully, so long as they comply with the DMCA, which means they have to comply with DMCA takedown notices. The other half of that is that they're supposed to comply with DMCA counter notices, where someone like KuttySark would make a counter notice claiming that the DMCA takedown is invalid in some way. And I cite to 17 U.S.C. 512. Letter C here is how you take down things with the elements of the notification being listed in subsection 3. But then subsection G is the replacement of removed or disabled material and other limitations on liability. There is no liability for taking down generally, but paragraph 1 shall not apply with respect to material residing at the direction of a subscriber upon receipt of a counter notification. Promptly provides the person who provided the notification a copy of the counter notification that it will replace the material within 10 business days, and then replaces the removed material and ceases disabling access to it. So that means that TeePublic wouldn't be liable for KuttySark's claim of copyright infringement if they put the material back up upon receiving a valid counter notification, and the elements of a counter notification are listed here in subsection 3 as well. But did TeePublic have any duty or requirement to put KuttySark's material up there? They're not the same kind of content host as, say, like a website host. If your hosting is with GoDaddy, or If you host your own website and your ISP gets a takedown notice and you make a counter notification and they don't restore access, maybe they're in violation of your copyright. But many of these websites have terms of service, like YouTube, that say, we don't have to host your content. We have no affirmative duty. So it's not copyright infringement to take the material down and leave it down, even when you have sent a valid counter notification, which is frustrating because it means that YouTube doesn't have to put your video back up when you get a false takedown and you file a counter notification. The good news is that there is a resolution to the Riot Games KuttySark DMCA claim. Riot Games has withdrawn or will withdraw the DMCA claim. They say, we want to thank players and rioters for alerting us to the takedown notice issued to an artist earlier today. Like many large companies, there are a number of teams and third-party agencies working to protect our IP. While we're still investigating what happened here, it's clear that this takedown request was made in error. We apologize for this experience. We want to assure you that we're actively reviewing. And this highlights the access to justice problem that we have with the DMCA, and this will be going in my February 8th report to that copyright consortium that's going to be discussing content ID and things, because that's how this happens. These large companies, even small photographers, hire companies like DMCA.com and others to police their copyrights, and many of those companies automate the policing of intellectual property and copyright. So they get something like a content ID system that identifies violations of copyright. There's probably a person, or maybe even not a person, but a computer that just goes through the posts and sends automated DMCA takedown notices. And at best, that person who might be going through these to clear them for DMCA takedown notices is probably just going like accept, 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 and hardly ever rejecting it unless it's super clear that it's rejectable. And they probably thought that KuttySark's depiction of the Alvis character of her own creation was similar to something they thought League of Legends owned or Riot Games owned, and so they just hit yes or accept on that particular item, leaving it to KuttySark to then file a counter notification. This is actually against current case precedent. The Ninth Circuit has said that you must consider the fair use of material, and so if they didn't consider fair use, they definitely didn't consider whether she had ownership, they're probably in violation of not just the law, but case precedent. Claiming her art for themselves through a DMCA takedown notice is also a basic copyright section 106 violation, section 106 being the copyrights, the right to prevent copies. So they're claiming ownership of her copyright that's violating in some way her right to publicly display her art. So she probably has a basic copyright infringement claim against Riot Games, at least for her actual damages. And if her art is registered with the US Copyright Office, which I doubt it, but if it is, then she has access to statutory damages and attorney's fees as well. She's probably not going to do any of that. The access to justice problem comes with someone from Ukraine having to figure out the US DMCA law, not knowing how to file a counter notice and having to figure that out, which I think she eventually did. She continues that she's made a post about it on Tumblr. She tried to contact TeePublic. They said, we are unable to reinstate this design because it was a DMCA claim from Riot Games after she filed some kind of counterclaim, which I'm assuming is a counter notice. I guess the rights and intellectual property of small creators are not protected on the TeePublic platform. So yeah, she was flat out told that she's not a large enough creator, that TeePublic doesn't want to go against Riot Games. TeePublic doesn't have to go against Riot Games. They're still in their safe harbor if they put the material back up at the direction of KuttySark for filing a valid counter notice. So that's just cowardly on TeePublic's behalf. I'm really not sure why they just kind of threw their creator to the wolves here. It's ignorant and it's cowardly. And it's also an access to justice problem because KuttySark would not have gotten resolution here from Riot without it becoming a big post on Twitter with 8,700 likes, 7,800 likes, 62,000 likes on the original. I retweeted this, although I'm not sure why it's showing that I didn't. I'll retweet it again there. And that's how that was resolved. So hopefully that will get resolved fully for KuttySarkArt. Maybe Riot Games will have a few words with their intellectual property enforcers. I doubt it. There's very little cost to content owners who file false DMCA claims, even though there is a law against it and case law against it. But that's what happened there. These companies hire people to look after their intellectual property for them and file DMCA notices. Because what would you want to do that if you were Riot Games? If you were a Riot Games executive, would you like to be tasked with sitting behind a computer and looking at the whole internet for copyright infringements and then typing out DMCA requests? No, they're going to automate that. And these are the victims of that automation. If you don't fall into, even if you do protect your work by making your own work, you're still at risk for a false claim by a large company who automated their DMCA takedown notices. Great job, Riot Games. Great job. Teespring banned a guy for a shirt that said piracy is not theft. Piracy is not theft. Piracy is copyright infringement. And we have a word for it. It's not theft. The problem with the DMCA system is that you have to accept jurisdiction of a court in California. Well, you have to accept jurisdiction of a court. It's not a court in California, is what it's not what it says. It says, if the subscriber's address is outside of the United States, you must accept jurisdiction for any judicial district in which the service provider may be found, and that the subscriber will accept service of process from the person who provided the notification. So you have to accept service, and you have to agree to jurisdiction in the judicial district where the service provider is found. TeePublic is located in New York, so that would be, if it is 10003, I think, is going to be Manhattan, so it's going to be the Southern District of New York. That's where TeePublic would be, and that's where jurisdiction for the case would be. Thanks for watching. Special thanks to my top supporters in February: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everybody has a great week. I love you all. Bye.